Okay, they did not want to make that easy on me, so we're going to start over again. Welcome to Title Talk Episode 3. We're going to talk about the title commitment. We're going to go through the first 4 pages today. It's a lot of legal mumbo jumbo and cover your ass clauses, but I wanted to take the time to go through it regardless, just to make sure that if and when you're purchasing a house, purchasing investment property, or even a realtor, you know what you're looking at when this is sent to you. So the first things first, we're on page 1, and we have the notice, which basically says that the commitment is an offer to issue title insurance. All claims sought against the company involving the content of the title commitment must be based solely in contract, which is that's interesting verbiage, and mainly the reason that I bring that up is typically if you're bringing up a title claim, it's for an item that wasn't included in the title commitment, something that we didn't catch and something that we didn't find. But again, they have to put it in there anyway. They're trying to cover their butt. So commitment is not an abstract of title, which is basically, I actually like the title commitment better than an abstract of title. It's not a legal opinion or opinion of title. We're just presenting you with the facts. The procedures used by this company to determine insurability of the title, including any search and examination, are proprietary to the company. Again, that's more specific to our underwriter than us. So pretty much anything that is insured with Fidelity, who is who we use, is going to kind of follow the same search and examination outline. But with that being said, as in any industry, we are all just people, and we can go to one underwriter and they'll tell us one thing one day, and we'll go to another underwriter and they'll tell us something else the next day. So it can be proprietary, really is a good word for that. Perform solely for the benefit of the title company and create no extra contractual liability to any person. So a lot of times too, especially if you're working with me, I'll do a lot of requests for like, hey, can you send that to me in an email? And it's kind of for that exact reason of anything that's said, especially when it comes down to the nitty gritty of the purchase. I want to make sure that I have that somewhere in writing. So the company's obligation under this commitment is to issue a policy to a proposed insured identified in Schedule A, which we aren't going to get to today. That's actually on page 5, but we will see the Schedule A that it's referring to in accordance with the terms and provisions of this commitment. The company has no liability or obligation involving the content of this commitment to any other person. Basically, it's saying that if you are listed as an insured, you are getting title insurance. If you're not listed as an insured, don't reach out with a title claim. So the next section is commitment to issue the policy. This is basically saying that subject to Schedule B Part 1, which we will look at, that's requirements, and Schedule B Part 2, exceptions, which we will also look at, the company commits to issue the policy according to the terms and provisions of this commitment. This commitment is effective as of the commitment dates shown in Schedule A, which, like I said, we'll talk about it. And each policy described in Schedule A only when the company has entered in Schedule A both the specified dollar amount, so that is the purchase price, and then also your loan amount, proposed amount of insurance, and the name of the proposed insured, which would obviously be like if you're purchasing it by yourself, if you're purchasing it with your kids, if you're purchasing it with your husband. That's what it's talking about with the name of the proposed insured. So another little side note under here, if all of the Schedule B1 requirements have not been met within 180 days after the commitment date, this commitment terminates and the company's liability obligation ends. So we typically won't close with any of the Schedule B1 requirements left open, but if we did, we'd need to resolve those within 180 days. So next we're going to go on to commitment conditions, and the first part is definitions. So discriminatory covenant. This is any covenant, condition, restriction, or limitation that is unenforceable under applicable law because it is illegally discriminatory. So basically, it discriminates against protected classes, which is based on personal characteristics such as race, color, religion, sex, orientation. The reason that they put this in there, we actually used to have deeds, and I've seen deeds in West Virginia that would say you know, can't be conveyed to someone of a specific color, sex, gender, etc. So they include that in there to basically say that anything that would include those clauses, they're negating that just right off the bat. Let's go. The next one is knowledge or known. And this is basically saying actual knowledge or notice, but not constructive notice imparted by public records. Land, this is the land described in Schedule A, and improvements located on that land by state law constitute real property. The land does not include any property beyond the described Schedule A, nor any right, title, and interest, estate, or easement in any abutting road, avenue, alley, etc., etc. So, and it does not modify or limit the extent that a right-of-way to and from the land is to be insured by the policy. So that's kind of interesting, and something that I always like to point out to people when talking about the title commitment or title insurance in general is we aren't actually, it's not like a homeowner's insurance policy where if a tree limb falls on your house, we're going to cover that. Really what we are specifically concerned about is the legal description to the property, and that's kind of what this is getting at. The land described in Item 5 of Schedule A. That's what we're insuring. So next is mortgage, which is a mortgage, deed of trust, trust deed, security deed, or other real property security instrument. Basically, this is just going over all different names for a mortgage, and it can be anything from a mortgage with an individual, like let's say your parents were lending you money and wanted to have a security instrument of record, or you got a loan from a bank. That's all under that same umbrella. So next is policy. Each contract of title insurance is a form adopted by the American Land Title Association, issued or to be issued by the company pursuant to this commitment. So a little background on this. The title commitment comes first, and basically this is the outline of kind of all of the requirements that we need to take care of. And then after closing, once we've cleared everything, once you've gone through everything with your bank, appraisals, so on and so forth, then, and once your deed is recorded, then at the very end of that process, we'll send you the original recorded deed most times and your owner's insurance policy. This isn't something that you necessarily need to keep a physical copy of. It doesn't hurt, but if you lose it, just get in touch with the title company that did your sale, purchase, whatever, and we can go ahead and send that over to you. So next is the proposed amount of insurance. This one is pretty easy because basically the proposed amount of insurance, so this says each dollar amount specified in Schedule A as the proposed amount of insurance of each policy to be issued. I'm going to simplify that even further and say that it's the purchase price and the loan amount. Those are the two proposed amounts of insurance. So proposed insured, each person identified in Schedule A. Again, in most cases, it's going to be the buyer and the lender. And if it's a cash deal, obviously there's no lender. So that is the end of page 1. On to page 2, where we're going to finish up definitions, which is public record. So this is a record or filing system established under state statutes in effect at the commitment date under which a document must be recorded or filed. So when we're searching public records, we'll do everything from a recorder of deeds to the Prothonotari's office, and basically what we're looking for is any lienable items. And I know I'm using a lot of fancy title words, but hopefully you guys have been hanging out long enough that we've talked about these, so you've got some idea. But essentially, the recorder of deeds is going to take more basic stuff like deeds, mortgages, death certificates, things like that, marriage licenses. Those sorts of things will all be available at the recorder of deeds office. And then if you want to get a little bit more specific, like maybe for credit card liens, things of that nature, they'll be recorded at the Prothonotari's office. And all of these different recording bodies, they all fall under public record. So next section is state, and then this is the state or Commonwealth of the United States in which the land is located in. So as I had previously mentioned, I've worked in West Virginia, Ohio, and Pennsylvania. I'm currently working in Pennsylvania, so in this particular case, it would be the state is referring to is Pennsylvania, which is the Commonwealth. So Just as a reminder, this is all under the umbrella of commitment conditions. So part 2 of commitment conditions is that if all of the requirements have not been met, Schedule B Part 1 requirements, this commitment terminates and the company's liability and obligation ends. So this is just circling back to why we make sure that all of these items are taken care of, or we have a plan to take care of them before closing. So the company's liability and obligation is limited by, and this commitment is not valid without, the notice, the commitment to issue policy, commitment conditions, Schedule A, Schedule B, Part 1 and Part 2, and a countersignature by the company. So basically that's outlining all parts of the title commitment. Number 4, company's right to amend. So the company may amend this commitment at any time. If the company amends this commitment to add a defect, lien, encumbrance, etc., the company is not liable for any other amendment to this commitment. So basically what that's saying is that if we're 2 weeks into a closing, we've sent out the title commitment and we kind of have an idea of what we're looking at. Like there's 2 mortgages, and I don't know, maybe they haven't paid their 2024 taxes, so there's a tax lien on there now. If something else comes up, if my searcher happens to find a credit card judgment along the way, they reserve the right to add that to the title commitment as something additional for us to clear. So next is limitations of liability. Company's liability is limited to the proposed insured actual expense incurred in the interval between the company's delivery to the proposed insured of the commitment and the delivery of the amended commitment. So what that's talking about, again, we're going back to the right to amend. It's saying, hey, if we missed something, we are limiting, or Fidelity is limiting their, and I'm going to use a big insurance word here, but limiting their exposure to risk, which basically is saying that they're only going to pay out a certain amount of money, and that certain amount of money is going to be limited by the actual expense incurred in the interval between the company's delivery, etc., etc. So, commitment resulting from the proposed insured good faith reliance to comply with requirements, eliminate with the company's consent any exceptions, acquire the title, or create the mortgage covered by this commitment. So the company is not liable under commitment condition 5A. So 5A is what we just went over, if the proposed insured requests the amendment or has knowledge of the matter. So again, this is going back to the amendment. So basically it's saying if my searcher didn't find it, if you found it as an agent, if the buyer found it and presented that to us, or what will also occur, and I think what they're really trying to protect themselves of, is the seller will turn around and say, well, hey, I had this additional mortgage that you guys need to pay off. And this is saying if the proposed insured, if the buyer or the lender had knowledge of that matter and did not notify us, we aren't liable. So the company is only liable under commitment condition 4 if the proposed insured would not have incurred the expense had the commitment included the added matter. Company's liability does not exceed the lesser of the proposed insured's actual expense. Company is not liable for the content of the transaction identification data. Company is not obligated to issue the policy referring to this commitment unless all of the Schedule B Part 1 requirements have been met, and the company's liability is further limited by the terms and provisions of the policy to be issued to the proposed insured. So, again, as previously mentioned, there's a lot of legal mumbo-jumbo here, but basically, number 5 is just kind of a huge CYA clause for number 4, which is the company's right to amend. The only things really of note in here that aren't in relation to that, which I think are kind of interesting and worth looking at, is the company is not obligated to issue the policy referred to in this commitment unless all of the Schedule B Part 1 requirements have been met. So that's why if we don't have everything that we need, if we're missing a payoff or if we're missing a tax cert, we can't close without those items. They're pretty important. Now there are workarounds. Those are the things that we can do, and we want you to get to the table just as much as anybody else. But that's, you know, that's a very hard line right there. So, and then we're moving on to number 6. Liability of the company must be based on this commitment, choice of law, and choice of forum. So, only proposed insured identified in Schedule A and no other person may make a claim under this commitment. So that's saying that either the buyer or the lender would have to make the claim. And that's the end of page 2. We're on to page 3. We're getting there, guys. So, B, any claim must be based in contract under the state law of the state where the land is located, restricted to the terms and provisions of this commitment. So basically that's saying that it has to be based under, in this particular case, Pennsylvania state law. This commitment as last revised, is the exclusive and entire agreement between the parties with respect to the subject matter of this commitment. So again, it's talking about the rights to amend again, and it's saying that the last amended commitment is the one that you should use, the commitment as last revised. So none of the ones before are needed. It's just the last revision. And that's the one that you should be going off of. So, between the parties with respect to the subject matter and proposal of any kind, whether oral, express, or implied, related to the subject matter of the commitment. So, the deletion or modification of any Schedule B Part 1, Part 2. This is talking about exception. This does not constitute an agreement or obligation to provide coverage beyond the terms and provisions of this commitment or the policy. So basically, and sometimes lenders will do this a lot, they'll want us to remove or change some of our exceptions, and basically this is saying that just because we do that, it does not constitute an agreement or obligation to provide coverage beyond what had been previously discussed. So any amendment or endorsement to this commitment must be in writing and authenticated by a person authorized by the company. When the policy is issued, all liability and obligation under this commitment will end, and the company's only liability will be under the policy. So that's interesting, and I feel like worth talking about, because basically it's saying that the commitment is only valid from the time that we issue it to the closing date. And then once you've closed, once your deed is recorded, and once the owner's policy has been issued, the title commitment is no longer valid. It can still be referenced. There's still important information on there, but it's not that's no longer, I guess I should say, the standing agreement with your title company. The standing agreement at that time would then be your owner's policy. Which, if you're interested, we can go over the owner's policy as well. Again, it's going to be a lot of legal mumbo-jumbo, but, sometimes, and all this stuff is worth looking at, and maybe you'll learn something, and maybe I will too. So if the commitment is issued by an issuing agent, the issuing agent is the company's agent. So technically at Modern Abstract, where I currently work, we are the issuing agent. Only for the limited purpose of issuing title insurance commitments and policies. The issuing agent is not the company's agent for closing, settlement, escrow, or any other purpose. The reason that they're pointing that out is because, like, Fidelity, for example, works with lots of different title companies, and has, lots of different people that they could work with for closing, settlement, escrow, etc. So, pro forma policy, this one is kind of weird. I have lenders request them from me every once in a blue moon, and basically, I'm going to give you my understanding, and then we can go into what this is stating, but it's almost like issuing the policy before its time. So like I said, lenders are specifically looking for this, and 9 times out of 10, I do think it's because they're looking for a better explanation of endorsements and to see what is and isn't going to show up on the final policy. So this specifically states the company may provide at the request of a proposed insured a pro forma policy illustrating the coverage that the company may provide. So essentially this is saying the same thing. If the lender or I guess the buyer, for that matter, wanted to see what the actual policy was going to look like once it had been issued. We can issue what's called a pro forma policy. So a pro forma policy neither reflects the status of title at the time that the pro forma policy is delivered to a proposed insured, nor is it a commitment to insure. So just, obviously keep those things in mind. Next is claims procedures. This commitment incorporates by reference all conditions for making a claim in the policy to be issued to the proposed insured. Commitment condition 9 does not modify the limitation of liability in commitment condition 5 and 6. So again, plenty of CYA clauses there, but basically it's saying that if you do need to make a title insurance claim, there are conditions to issuing that claim, and basically the limited experience that I have with the claims process is a buyer, a seller, an agent, someone comes to me and says, hey, we're having this particular issue. I send it over to my claims department. They request a bunch of information from me to kind of see where our liability lies. And honestly, if I'm totally honest, that's kind of the extent that I go in that department. At that point, it's in Fidelity's hands, who is, again, my particular underwriter. First American is another big one. Stewart Title, there's all different kinds of title insurance underwriters, but the point is that you can contact me with that information, but then once I sign it over to Fidelity, it's kind of out of my hands. So class action, any claims and disputes arising or relating to this commitment, and including any service or matter in connection with issuing this commitment, any breach of service or other matter, any breach of commitment provision, or any other claim or dispute arising out of relating to the transaction giving rise to this commitment must be brought in an individual capacity. So that's kind of back to what we were talking about before, too. This is saying that, if you do have a title claim, just send me an email. Don't get an attorney first. No party may serve as plaintiff, class member, or participant in any class or representative proceeding. So don't get a bunch of people together and try and file a class action, and don't, honestly, it probably wouldn't be worth it for you to get an attorney involved immediately either. Typically, it's best to just contact whatever title agent you were working with, let them know the issue that arose, and just kind of go from there. So arbitration, this is basically like referring to like paying out policies. The policy contains an arbitration clause. All arbitrable matters when the proposed amount of insured is $2 million or less may be arbitrated at the election of either the company or the proposed insured as the exclusive remedy of the parties. A proposed insured may review a copy of the arbitration rules at the link. So that's actually alta.org, and what I'll do is I'll actually copy and paste that link into the comments, so if anybody wants to look at that later, they are able to. And then page 4, this is, I don't know if you remember back, but one of the other requirements that they went through was making sure that it was signed. So this is the countersignature by the President and Secretary of Fidelity National Title Insurance Company. So thank you for joining me.